Okay, in today's episode of Red Flags, I'm going to talk about 6 sure signs, at least almost certain signs, right, that you're being tested on the political question doctrine. Now, if you have an essay on the political question doctrine, there's all kinds of different possibilities we can throw at you, but remember from the prior video, if the call of the question is, should a court hear this case, right, is this a justiciable case? Should a court entertain this case, right? If that's the call of the question, political question doctrine is one of the things you want to consider. But there are, under the political question doctrine, again, 6 red flags that would signal you that almost certainly you're being tested on the political question doctrine. And this would more likely be, in these fact patterns would more likely be in a short answer question or a multiple choice type question, because the answers in these cases are quite clear, right, that these are non-justiciable questions. Number 1, if you see a reference to impeachment and removal on a fact pattern and constitutional law, there is almost no conceivable reason why you would see a fact pattern about impeachment and removal, right, of some federal official, be it the president, a federal judge, some other official, it doesn't matter. It's almost inconceivable that you would have an impeachment and removal fact pattern or impeachment and removal referenced in a fact pattern unless you're being tested on the political question doctrine. That should be a trigger for you because, of course, the Supreme Court in the Nixon case, not the President Nixon case, but the Judge Nixon case, said that matters around impeachment and removal, right, are non-justiciable political question because that question is textually committed to Congress, right? The House is the sole organ of government that would decide whether to impeach or what is an impeachable offense, right? And the Senate is the sole organ of government, right, authorized to try impeachments. So if you see a reference on a con law exam to right, impeachment and removal from office, you are almost certainly being tested on the political question doctrine. Number 2, if you're a student of mine, you know I love as tragic as it is for legal purposes, I like relying on the Gilligan versus Morgan case because that case covers a number of different ways that a question can be a political question. But that was the question, that was the case rather involving the National Guard shooting at Kent State. If you see in a fact pattern any indication that whoever's challenging the government is asking for a court to supervise the military in some way, right? And we're talking here about military decision making, military strategy, tactics, and in particular in the Kent State case, military rules of engagement, right? If you see a request, right, from a party in an exam fact pattern for a court to get involved in supervising military, again, tactics, strategy, or rules of engagement, I would be very suspicious if I were you that I'm being tested on the political question doctrine because once again, the court in that case said that's a non-justiciable question. There are no judicially manageable standards, right, for a court to use in deciding how to supervise military decision making. Number 3, if you see in a constitutional law a reference to a ballot question or a referendum initiative, you need to know what you're being tested on there. A ballot question / referendum initiative is that thing you see when you go to vote, right, where there are, you're not only voting for candidates, but you're voting on specific questions, right? It might be a millage, or it might be, whether to amend the state's constitution, whether to legalize marijuana, right? Things like that you're being asked directly, right, yes or no on these questions. Why would you see that on a con law exam? Well, because that is direct democracy, right? That the ballot questions and know those language. Google it if you have to. Know that language, right? Ballot initiative, right? A ballot question, referendum initiative. Those are those types of questions that are on the ballot. When we vote on those questions, we're engaging in direct democracy, which we're not supposed to be doing under the guarantee clause of the Constitution, which says every state, right, is guaranteed a Republican form of government, which means representative government. Nonetheless, the court has said that is a political question, right? The court declined to intervene in states using that method of lawmaking. Next up, ratifying a constitutional amendment. If you see a fact pattern about the manner in which a state went about accepting or rejecting a constitutional amendment under Article 5 of the Constitution. The court has said that, you know, the reasonableness of how states do that, when they do it, right, whether they do it, how they do it, right, those are questions that implicate the political question doctrine. It's up to Congress to decide, right, whether to accept or reject a constitutional amendment. It is not up to courts, and therefore courts have held, again, ratifying that ratification process, right, the amendatory process under Article 5 is a political question. Number 5, if you see a reference in a common law fact pattern to political or partisan gerrymandering as distinguished from racial or ethnicity-based gerrymandering, right? If you see a reference to, and you have to know how to spot that. Democrats are claiming that Republicans have gerrymandered the state, right, for political advantage. Republicans are claiming that Democrats have gerrymandered the state for political advantage. The Green Party is claiming that both parties have gerrymandered the state, right, for political advantage. Anytime you see that fact pattern about the allegation being that there's gerrymandering and that the gerrymandering is based on political or partisan advantage rather than, right, ethnicity or some other protected classification, then you're being tested on the political question doctrine, because partisan gerrymandering, the court has now said, right, again, implicates the political question doctrine. It's a non-justiciable question. Essentially, just about every district in the United States, voting district, right, is somehow gerrymandered for political reasons. That's sort of the nature of the beast. And the court says we have not found a way yet to manage that issue. There are no judicially manageable standards for resolving that question. Finally, number 6, right, again, talking here about the six surefire signs that you're being tested on the political question doctrine. This one is a little iffy because it's a plurality opinion, but there's a concurring opinion that makes it sort of 5-ish. Anyway, I would say look out for a fact pattern where the president wants to get the United States out of a treaty, right? And there's some allegation that the president can't withdraw the United States from a treaty because you need the Senate to ratify a treaty. So the argument here would be you would also need the Senate to get out of a treaty. In a case called Goldwater versus Carter, the court declined to hear that kind of a case, right, involving foreign policy decisions, and particularly involving the cancellation or the withdrawal, right, of the United States from a treaty. In that case, President Carter taking the United States or declining, right, to honor a treaty between the United States and Taiwan. The court saying, look, federal courts should not be right, involving themselves in this kind of dispute between the Senate and the president as to a foreign policy matter, right? There's no way for a court to resolve that. So, the 6, or not the only 6, but 6 things you want to look out for in a common law fact pattern, whether it's, again, short answer, multiple choice, or essay for that matter. Impeachment and removal from office, military rules of engagement and issues like that. Ballot questions, right, and referendum initiatives. The ratification or mandatory process for the under Article 5 of the Constitution, partisan/political gerrymandering, and the president wants out of a treaty. Those 6 things will be red flags for you that you're being tested on the political question doctrine. So I'll be back to talk about some other issues later. Hope that helps issue spotting wise. I'm happy to say that Lainey is laying here very quietly today, so that's nice. We'll see you next time.